This week on GrokTALK, my guest is Dan Richard. He is a constitutional scholar, self-taught, and has been on a mission to convince the courts in the state of New Hampshire that what we've been calling elections in this state are unconstitutional. We'll also have the beer of the week, and you never know what else we might slip in there. GrokTALK is brought to you by GrokTALK.com and Grok Media LLC, and the program starts in less than 60 seconds. New Hampshire Republican Governor Kelly Ayotte has been making a lot of noise about how she's funding education. The Republican budget she just signed provides more money for education than ever before. She even bragged the other day that New Hampshire is top 10 in the country when it comes to funding our children's education, as if giving money to school systems has anything to do with learning. If you look at the math, and if you got schooled in New Hampshire, the odds are good it's not your best subject. It's the exact opposite. The more money we throw at schools, the less kids learn. We're committed to wasting money on an experiment that failed, unless wasting money to drive parents to homeschool their kids was the goal. We prefer to pick on Democrats, lower hanging fruit and all that, but our rhetorical woodshed doesn't discriminate. If that sounds refreshing, you need to check us out. This is Steve McDonald for Granite Rock, and we'll keep shining the light on them for you. Welcome back to GrokTALK. We are here today, as promised, with Dan Richard, our constitutional scholar, self-taught. He knows more about election law than the people involved in election law, which is a pretty interesting thing to say because he's been, pushing this lawsuit for 7 years now. You've been taking the state to court to try and convince the courts to say, oh, by the way, what you call elections, it's not constitutional.
No, you're absolutely right. And thank you for the introduction. The situation with the election law is really shameful, and we have a big problem statewide where, for example, the Attorney General's office in this case is, instead of upholding my rights, they've chosen to uphold they've chosen to act as a legal defense counsel for the named defendants who refuse to obey the law. So, I'd call that a little bit of conflict of interest, and this particular Attorney General is up for renomination, and so I'll be sure to be there and express my opinion.
I have a few complaints about him as well. If you want to read about Dan's case, there's a lot of places you can do it. We've posted a good deal of information on GraniteRock.com, but you can go to Daniel-Richard.com and learn all about Dan, support his effort to bring legal elections to the state of New Hampshire, which is a thankless task, and he's devoted all of his time and energy to it, and he needs your support to make legal elections a thing in the state. But that's not what we're here to talk about, even though we could talk about that for about 40 hours. We are here to talk about grand juries and some things about grand juries that Dan knows that you need to know. So I'm just going to kind of cut you loose. Why don't we start with the history and then talk about what's going on today, maybe why we need these things so badly. I know we've talked about this separately, but we need to tell our audience about this. And then what needs to happen.
Yeah, there is obviously, with the breaking news in the last couple of weeks with the horrific incident in Berlin where there was a mistake made by a magistrate where she gave someone bail and it caused someone their life. And so there's a lot of backlash, the Claremont decision and so on. There's a lot of backlash and a lot of people asking questions about, what's up with our judiciary? Do we need judicial reform? Is that what we're looking at? And what does that look like? And so the answer to all of our problems left behind by the founding fathers is actually the state constitution, part 1, the Bill of Rights, Article 38. The last article in 1784 was Article 38. And in that provision, it tells us that we should have a frequent recurrence to the fundamental principles and to go back and revisit our founding principles because they are amendable. One of the unique features of New Hampshire's original 1776 Constitution was the fact that it couldn't be changed. There was no provision in the 1776 Constitution for it to be altered. But the one we live under now can be altered. And so we've had a lot of those changes through the years. And one of them has been the changes to the judiciary, and more importantly, removing a vital tool that we, the people, no longer have at our disposal. and that is the grand jury function beyond what you are taught today and how they work today. Today, they don't work in they don't perform all the tasks that a grand jury can in fact perform in under the founding principles. So most of us have been taught in school about the Fifth Amendment in the U.S. Constitution. See, we're not teaching. We have a constitutional crisis in New Hampshire. Back to our judicial problems. Not a single judge in the state, none, and none of the lawyers either, have taken a course in the state constitution that would establish them to be what I would consider a court of competent jurisdiction. But I digress. So what we're taught in school is the Fifth Amendment. We taught the Federal Bill of Rights because, see, now we have a national central democracy called the United States government. And so the Fifth Amendment is what we're taught in school, and it talks about the grand jury there. And I'm going to start there because it's a great jumping point for what people may already know about the grand jury. The Fifth Amendment to the U.S. Constitution says as follows: no person shall be held to answer for a capital or otherwise infamous crime unless a presentment, keyword presentment, that's what we're here to talk about today, the presentment power, or the indictment of a grand jury, except in cases arising out of land and naval forces and so on and so forth. But the key is the presentment power. What does that look like? Because see, today, what we have is we have strictly the grand juries are chosen by the county clerk of each county in New Hampshire. That power has been delegated by the legislature away from the people to the clerk of each county courthouse so that it can set the schedule for that county. And it's only selected to do one thing, and that is to carry out the indictment or the grand jury function to investigate whether a case brought by the county attorney or the state's attorney is sufficient to warrant an indictment that leads to a legal proceeding against an individual involving a serious crime. That's what they currently do. You've heard the joke, you can indict a ham sandwich, right?
Yeah.
Because the grand jury simply rubber stamps. Look at the Marconi situation that we've been following in the news, right? We now know that the sitting attorney general went to a grand jury without a witness complaint. There was no sworn affidavit alleging that Judge Marconi did anything wrong or that she's alleged to have done anything wrong, and they issued an indictment. So, but that's all. It's not a trial. It's strictly,
so you don't even need a ham sandwich. That's what you're saying.
It's apparently in New Hampshire, the ham sandwich is no longer required.
Right.
But that's what happened to her. And so, but the key to that is that's what we're taught in school, and that's what all of us know about grand juries. Let's talk about a solution to a really big problem. And that is to go back in history. As you know me, as we've gotten to know each other over the last few years, I'm all about history. Mm-hmm. I don't come up with new ideas myself. I simply say, hey, we used to do X way back when. And gee, it wasn't broken when they tried to fix what it is, like our elections, right? But, back to this whole grand jury thing. So what ends up happening is I uncovered the original statutes from 1791. See, the sitting, a grand jury is supposed to be made up of your local citizens, and it's part of your civic duty. We know about the regular jury duty that people get called for civil and criminal cases, right? And we hear a little bit about grand juries, but they're conducted in secret. So to protect the identity of the accused, so that if they in fact have done nothing wrong, and we'll get into that next, and that is, what are the other powers of this, quote, citizen grand jury, and how do they get chosen, and how, or I should say, how did that come to be in the past? So in 1791, I transcribed from Google, by the way, for any of you geeks out there that want to follow along with some of my research. I often go to Google Books and type in New Hampshire Constitution, and I have found an extraordinary depth of documentary evidence of state constitutions and laws and history books, including, fascinatingly enough, the conventions, the constitutional conventions held before our current Constitution came to be. But that's where I found a lot of this stuff. The Google Play Store, write this down, all you geeks like me. The Google Bookstore, New Hampshire Constitution, and there's all kinds of stuff there. So this is where I found this particular law, passed February 8th, 1791. It went into effect September 15th. An act regulating the choice of service of grand jurors. Be it enacted by the Senate and the House of Representatives and the General Court convened. That's exactly what our statutes today say when the legislature passes a new law, isn't it?
Yes, they do. Every single one.
That 40 days at least before the sitting of the Superior Court of Judiciary in each county in this state, at the stated terms by law, appointed for holding the same, the clerk of said court shall issue a precept to the clerk of each town. In other words, he's going to send out orders. The judge is going to sign an order, and it goes out to each town. And the said town clerk shall 7 days at least before the day of holding the meeting for choosing such grand jurors, post up at the usual place of notifying a meeting of such town, a notification of the inhabitants to assemble for the purposes of choosing grand jurors, agreeable to the precept to him directed, and the said inhabitants, when assembled, shall proceed to choose a moderator to govern in said meeting. Fascinating. Just like a regular election, the moderator is in charge of the election process, right? Isn't that what we do today for a regular election, town election, state election, right?
That's how it's supposed to work.
So they select a moderator and proceed to conduct this election and elect the number of grand jurors required by the order. And on the first day of sitting thereof, at such hour as said precept shall be ordered, with doing therein, and when any person, I love this part, and when any person chosen as aforesaid to serve as a grand juror shall make sufficient excuse in the judgment of those assembled at any such town meeting, that they may excuse such person proceeding to choose another. In other words, if you want to be excused from jury duty, look your neighbor straight in the eye and tell him why you shouldn't do your duty. You like that?
I like it quite a bit. So we've got this grand jury.
Yep.
And we've had them since 1791 and probably sooner than that, but we have an actual statute for them.
Yeah, these are instruments of the common law, the practice of common law from England, because that's what we brought to our American shores with the Mayflower Compact, which became the foundation of Massachusetts. And then, of course, we divorced ourselves from Massachusetts along political and really religious grounds predominantly. But yeah, we've had it that long.
That's impressive. So I love the history, and today we don't do anything quite like that. But back then, and I was reading up a little bit on this earlier, one of the purposes of a grand jury is to hold the government accountable.
Exactly right. So let's talk about what previous grand juries have done, because there's hundreds of years of history of this. So it's not like they can make this disappear. This is simply by dumbing down our culture, no longer teaching civics in school, and not adequately covering New Hampshire history, not American history, because that's what we're doing. We're getting a bait and switch, right? We're being taught the U.S. Constitution and American history to not focus on the all-important local element. And by keeping us ignorant of our own local affairs, requiring who? The legal society and their brothers and sisters for their profit and emolument is what this has turned into, right? What does Article 10 say?
Yeah. Well, that's the right to rebellion. Let's talk about that. We one of the reasons we brought this subject up was because of You talk about the incident in Berlin, the situation in Claremont with the Claremont cases 1 and 2, Conval. There's a lot of legal examples. There's the situation with the New Hampshire bar, which we talked about the other day offline. And so there's this basically the situation in New Hampshire where we appear to have what has been called this country club culture where the AG's office, the people in power, and then a bunch of people in the background are all just sort of doing these things, and they're all supposed to report to each other. They're all supposed to police each other, and they're not.
Right. No, you're absolutely correct. And so I want to get into this point for your audience to share with them the importance of what they're capable of doing. So, indictments we talked about, are the current process by which we all know. That's what a grand jury does. It issues a bill or a true bill or no bill, right? But a grand jury impaneled, a citizen grand jury, has the capacity to investigate whatever it wants. It could investigate government conduct just to ensure that the government is following through with its obligation after it's taken an oath of office. Any public official has taken that oath. So it can investigate whoever and whatever it wants whenever it feels like it. So upon finding a series of issues leads to how broad this inquiry can be. So let's start level one. True story, state of Florida, turn of the 20th century, right? In the early 1900s. A local citizen grand jury found the local tax collector was keeping the taxes that he was collecting for as part of his job assignment of collecting taxes. But he was only keeping it in his office behind a simple locked door. There was no safe to secure the money, to secure the people's money. The citizen grand jury got wind of this defect and made a recommendation to the local officials, and that recommendation led to a solution. The local officials said, "Yep, you're right. This is something we need to address." They did. And what did they do? They bought a safe and they fixed the problem. Mission accomplished. That's how simple a grand jury function can be from that on up. So let's get to the next point. Let's say a local official is doing something that's questionable, but there's no malice intended. In other words, there's no ill intent, right? There's no mens rea. There's no criminal intent to do wrong. There's not even a willful. It's not even a knowing. There's a public official has made an error. You can then still have a finding, a fact, that this error happened, which leads to local officials making recommendations to fixing a problem. So now let's take that to the next level. Someone now is knowingly violating their oath, right? Let's say they're taking, they're helping themselves to government resources, and on the whole spectrum is wide open. But let's say a minor infraction, you're taking paper and ink from your town hall, right? You're taking paper and ink paid for by the taxpayer, and someone's ratted you out, and you're taking it home, right? So what's that likely to lead to? Likely lead to a notice, a sit down, a warning possibly, or conversation. Is there evidence? Were they seen on camera? So on. But either way, it can lead to any of those simple solutions: a letter of reprimand, a motion to sanction or censure, a motion to terminate, or even further, if it finds that the public official or the grand jury made up of all local citizens, again, not lawyers, not judges, lay people, they don't make the decision whether they have enough evidence to go after somebody. The county attorney that's what the presentment is. You present to the county attorney your investigation into A, B, C, or D. And that is then for the county attorney to make the case. Now, maybe he doesn't make the case, maybe he does. But either way, and this is a very powerful tool. Imagine if we had this functioning today, because today what we have is, to many of your readers and your audience too, is the municipal association. We now have been sold the municipal association statewide as a way of mitigating the financial consequences of public officials doing wrong in order to keep your premiums down, right? So every time someone does wrong, a law firm, the municipal association, races to their rescue to defend them and to use taxpayer dollars, because they're getting paid by who? The taxpayer. To do what? To indemnify and to not hold the wrongdoer and have to pay for the consequences. So this is sad and an ongoing problem.
So if we were running grand juries the right way, you could have a grand jury come together and compile evidence about whatever wrongdoing it is. And I mean, read Granite Rock, you'll find lots of local evidence of people in positions of power who are ignoring the law, who are ignoring statutes, who are ignoring particularly the right to know laws, and spending obscene amounts of money to keep people from getting information to which they are publicly and legally entitled. And the judicial system and the lawyers, and they hire lawyers on top of lawyers, and the judicial system's like, no, you don't really get to see that. And it's like, and you can't get rid of these judges. I mean, you can. Obviously, the legislature has the power to vacate the judiciary, but they're never going to do it. Getting them to impeach, surprisingly, they've done it a couple times in the last few decades. But overall, there isn't really a mechanism for the people to bypass the legislature. Basically, people just sit here and they're like, well, I'm helpless. I can't do anything.
Well, you're exactly right. And what you've done is you've stripped the people of their oversight capacity. Because again, Article 38 says that we have total authority to oversee them for everything they do. And so right to know law has been used against us, the passage of it. If you look at Article 8 before the right to know law was added to the Article 8 in the Bill of Rights, there were no caveats. In other words, public accountability was to be understood as total and complete, not a loophole with exemptions, because they've taken the exemptions to produce public records as the written text, and that the statutes can only enforce the written text of the Constitution for that provision. Meanwhile, they ignore the written text of the Constitution in many, many other aspects. For example, Article 6 of the Bill of Rights in the Claremont decision, where the court completely ignored the fact that in order to interpret Article 83, the judge had a duty to look at Article 6, its companion piece in the Bill of Rights, as adopted by the founders, and not for some rogue judge in 1993 to come up with a brand new definition hundreds of years later.
Even if you just look at Article 83, if you're going to say that the word cherish means that you have to cherish public education, but it completely ignores seminaries, religious school. I mean, it says it right in the freaking Constitution. You can't just cherish one and not the other, and they aren't funding religious schools at all.
Right. Right.
So if you're going to say you have to give $7,000 per student to a public school, you have to give $7,000 per student to a kid going to a seminary, and they're not doing it. And it's so right there in your face. And lots of people have brought it up. Ian Underwood, who writes for us, has brought it up a million times in some of the funniest and most logical ways possible that make it look like these people are frigging idiots. And it's just like so blatant. So
Right.
I guess what people really want to know is, what do we need to do to try and give the people their power back and make this better?
Well, you mentioned removing or correcting the judiciary. The first thing I want to say is that your audience needs to be aware that the majority, I'd say 99.99999% of everyone involved today, isn't responsible for creating the mess. The question we have to ask ourselves is that once they come to the knowledge of the problem, are they in fact going to fix it, or are they going to kick the can down the road? That leads to a whole different problem. But one of the things I'm working on that I've been asked to examine is the issue of 72A and 73A. Both have caused tremendous amounts of damage to public accountability because of that whole nother conversation, another story. But they are a companion to this whole grand jury problem, that changes to our judiciary, the changing of the Bar Association from a non-profit, unincorporated body into a monopoly power. They like to talk, the Claremont judge, or the Claremont decision talks about, it gets into its examination of the Constitution, but in fact, where'd they go to school? They didn't. Literally, they didn't. None of them went to a school anywhere, anyhow, anytime where they took a course in state civics. So what are they relying on? Precedent. The state court is relying exclusively on precedent because none of them academically have taken a curriculum. They can't point to why, because such a course doesn't exist. So 73A and 72A were achieved because we have an ignorant population. We have a population, a citizenry of smart people. It's not that the people are dumb. It's that they've had this information withheld from them on purpose. And so that they don't even know what it says. For example, Article 83, the word cherish, you know what the proper meaning of that word was in proper application? It is the job requirement of school teachers, because if you read Article 6, the legislature was given authority to grant charters. See, people have lost sight of the fact that in 1784, how did you go into business? You got a charter from the legislature. Why? Because that's what you did when the king was the sovereign power, right? What happened to the Massachusetts Bay Colony when they put all the tea in the harbor, right? The King of England did what? He revoked their charter, stripping from them the capacity to do business. So today we have the Secretary of State's office, its corporate division. It, by statute, now handles what the legislature used to do, which is to issue corporate charters. See, Phillips Academy, Dartmouth University. What are they? The first charter schools in New Hampshire.
Correct.
So the word cherish, when you look at all of the issues written in Article 83 that legislators, that would be human beings, not the legislature itself, and magistrates of future government, is talking about Article 83, will hold these in high value. What? When they grant the charters so that the teachers, the job requirement of the teachers teaching the kids, they'd have to meet, and that's what the history shows us. But back to Article 72 and 73A. Article 72A was created to remove from the legislature the ability for it to have oversight over the courts. Go read, Steve, when you have time, go read Part 2, Article 4, and you'll notice that the Founding Fathers gave the executive branch the power, the governor, the power to nominate a judicial member, a judge, the executive council to concur or deny, and then the legislature was the gatekeeper. It makes the law, and it oversees, and did that, like you talked about earlier, that there were some, in the early history of the state, impeachable offenses where judges were in fact impeached. And how did they do that? Through the legislative process, through the fact that the courts did not have that oversight, because that's what the Bar Association has done. The Bar Association has now overseen the discipline of its membership, stripping from the legislature the power to oversee the judges, the lawyers, and the courts. So these are some serious problems. And then, of course, lastly, 73A, quote, the rules so proclamated shall have the force and effect of law. that sentence that I just cited was not in the voter's guide in 1978. The voters had no idea of knowing that if they passed 73A, that the court would now start making law, which violates separation of powers. They can't make law. And I'll finish up with this for my commentaries for your audience. Milton Friedman, one of my favorite people in history, in modern history, says government exists to do four things. Four things it's supposed to do. One, homeland defense. Defense of the homeland, right? What were they doing? Why did you have to pay a tax in 1723 in New Hampshire? Because you needed the protection of the king.
Basically.
Two, protect one citizen from another. Simple. Protect one citizen from another, or one citizen from 25 or 50 or 100. Number three, to establish the rules of the game, property rights. What are the rules? What are the borders? What are the boundaries? What are the rules governing this arrangement, right? Regulating commerce. What are the rules governing property? That's number three, and that's for the legislature to do, right? And fourth, to have courts of law to adjudicate the first three. That's it. And the reason the government doesn't do a good job at number two, protecting citizens one from another, is it's too busy doing everything it ought not do.
That's true. That's also why our schools suck so much.
Well, that's it. When you look at the experiment, and that leads to a whole nother lengthy topic on Claremont and possible solutions. But grand juries is part of, in my opinion, is part of a new modern revolution. If we're going to roll back, remember, I had this conversation with Ian Underwood about consent, and he brought up to me the very obvious point. Under the current consent clause of the state constitution, if 2/3 of the society agree to a change to the laws of the land, it gets forced on everybody. He said, well, how is that consent? Right? So he makes a valid point. That's why I wrote that article that I sent to you to publish.
I did.
Consent.
It went up today.
So on the issue of consent, that's why I was raising that point, right? What does that look like? And the full answer to that question, and he and I didn't get to finish my full answer on that, but that would have been that Article 3 says it well. In order to ensure the protection of others, protection of what? Their rights. It takes an educated citizenry that participates in the process. I hate politics, but I had to get involved at some level because I came to a horrible reality. That horrible reality is, as much as I hate politics and politicians, that if I don't participate in the process, someone else is going to show up in my place and make decisions about my life I don't appreciate. And so for that reason is why I got involved. And then I opened Pandora's box and jumped in with both feet with no parachute. And here I am still litigating in the courts.
All right, Dan, we are out of time, and I appreciate your making time to talk about this. I think we're going to try to make this a more regular thing where we'll just pick a topic, and I'll let you go for 30 minutes, and we'll do that maybe once a month or whatever. What do you think?
Like a plan, Steve.
All right, Dan Richard,
always a pleasure,
thank you for your time.
You're welcome.
You have a great day, and thanks for fighting, man. Thanks.
You're welcome. We'll talk to you soon. Bye-bye.
Hey, I'm back to tell you about a beer I tried this week, and I don't know, with a name like this, how could you not give this a whirl? It's called A Little Something Something. It's by Lagunitas. They sell a lot of IPAs. I like IPAs. This is an IPA. It says it's a smooth and silky IPA, and it is pretty smooth and silky. Not a bad beer. I enjoyed it. I would probably buy it again, and if you're interested in giving it a whirl, you can probably find it at your local store. It is hoppy. It's an IPA. If you don't like them, you probably won't like this. But I thought it was pretty good. And yeah, next week, I think I'll try to find something for the ale and lager, etc. group. We'll try something else. As much as I want to drink another IPA, just for you guys. That's it. See you next week.